Good morning. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 3438 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3438, to amend Title V United States Code to postpone the effective date of high-impact rules pending judicial review.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Washington's regulatory system is a system that virtually every day places new obstacles in the path of American jobs and economic growth. The biggest obstacles of all are new regulations that impose more than $1 billion per year in costs on the American economy. Struggling workers, families, and small business owners have every right to ask why regulations that cost this much are ever promulgated at all. Surely there are less costly measures that are effective and should be adopted instead. Those less costly measures would allow many more resources to be devoted to job creation and productive investment. But billion-dollar rules are promulgated, and there are more and more as the Obama administration grinds to an end. This is one of the reasons our economy has faced so much difficulty achieving full recovery under the Obama administration's misguided policies. Making matters worse, when billion-dollar rules are challenged in court, regulated entities must often sink billions of dollars into compliance while litigation is pending, even if that litigation ultimately will be successful. This is money for job creation and economic recovery we simply cannot afford to waste. The Review Act, introduced by Regulatory Reform Subcommittee Chairman Marino, is a common-sense measure that responds to this problem with a simple, bright-line test. Under the bill, if a new regulation imposes $1 billion or more in annual costs, it will not go into effect until after litigation challenging it is resolved. Of course, if the regulation is not challenged, it may go into effect as normal. This is a balanced approach, and it provides a healthy incentive for agencies to promulgate effective but lower-cost regulations that are more legally sound to begin with. I want to thank Subcommittee Chairman Marino for his work on this important legislation, and I urge all of my colleagues to support the bill. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte and members of the committee. As the President of Public Citizen has observed, the cost of regulatory delay is far more severe than generic inefficiency. Lengthy delay costs money and lives. It permits ongoing ecological destruction and the infliction of needless injury, and it enables fraudsters and wrongdoers to perpetuate their misdeeds. And so rather than alleviating these problems, H.R. 3438 would clearly exacerbate them. Accordingly, I must oppose this ill-conceived legislation. Despite the bill's colorful short title, 3438 would have a pernicious impact on rulemaking and the ability of agencies to respond to critical health and safety needs. In essence, the bill would encourage anyone who wants to delay a significant rule from going into effect by simply seeking judicial review of the rule. We all know that the judicial review process can take months, if not years sometimes, to finalize, especially if the appellate process reaches the United States Supreme Court. Thus, rather than ensuring predictability and streamlining the rulemaking process, this bill would have a completely opposite impact by making the process less predictable and more time-consuming. If anything, this bill would empower the very entities that cause the serious health and safety risk to delay and possibly derail legitimate efforts by regulatory agencies to respond to such threats. And as with other bills proposed by some of my colleagues, This legislation myopically focuses only on the cost of a proposed rule while ignoring the rule's benefits, which often exceed its cost by many multiples. In closing, there's a broad agreement among experts in the administrative law field that our nation's regulatory system is already too cumbersome and slow-moving. In addition to the Administrative Procedure Act's procedural mechanisms, which are designed to ensure an open and fair rulemaking system, Congress has passed various additional federal laws that imposed further rulemaking requirements. And rulemaking agencies must also comply with a number of executive orders issued over the past several decades that have created even additional layers of analytical and procedural requirements. The result of this dense web of existing requirements is a complex, time-consuming rulemaking process. In response to the explosion of analytical requirements imposed on the rulemaking process, the American Bar Association, no less, as well as many administrative law experts, have urged Congress to exercise restraint and assess the usefulness of existing requirements before considering sweeping legislation. Imposing new analytical procedural requirements on the administrative system also carries real human and economic costs. And so rather than alleviating some of the problems, H.R. 3438 would clearly exacerbate them. And so accordingly, I urge all of those of us who think this thing through to oppose this ill-conceived legislation. And I thank the chairman.
Mr. Chairman?
Chair thanks the gentleman, and it's now my pleasure to recognize the sponsor of the bill, the gentleman from Pennsylvania, Mr. Marino, for his opening statement.
Thank you, Chairman Goodlatte, for bringing the Review Act up for committee consideration today. I also want to thank the other members of the Judiciary Committee who have joined me as co-sponsors. The Review Act rests upon a simple premise that regulations with annual costs exceeding $1 billion annually should receive full judicial review before they go into effect. The regulations we are concerned about are so massive that their compliance costs are felt nationwide and touch every corner of our economy. It is not only prudent but appropriate that agreed parties have their day in court and that executive agencies must justify their reasoning and the legal underpinnings of their rulemaking. Requiring American taxpayers and businesses to comply before this process runs its course reeks of injustice. Historically, these high-impact rules, with cost over $1 billion annually, have been few and far between, historically. However, since 2006, there have been 26 in total, but in recent years, their number has grown exponentially, alongside the growth and reach of the regulatory state. There has been an average of 3 over the past 8 years and 6 in 2014 alone. And although some may insist that the straightforward reforms in this bill overreach, recent events indicate otherwise. Last summer, in the Supreme Court's decision in Michigan v. EPA, we saw firsthand what irreparable harm can occur when expansive, costly, and poorly crafted regulations are not given time for review. In this case, the court found that the EPA had promulgated its utility MACT rule through a faulty process and on legal infirm grounds because it chose not to consider costs when promulgating the rule. The cost of the rule were estimated by the EPA itself at $9.6 billion per year. That's billion with a B. In return, the EPA's best estimate of potential benefits were in the range of a mere 4 to 6 million, with an M, million annually. As the late Justice Antonin Scalia wrote in his opinion for the court, quote, "One would not say that it is even rational, never mind appropriate, to impose billions of dollars in economic cost in return for a few dollars in health or environmental benefits. Unfortunately, for workers, homeowners, and taxpayers across the country, the utility enacted rule remained in effect as litigation took years to work itself to a final decision at the Supreme Court. When review finally got to the court, the effects were nearly irreversible. Action on the Review Act is a reasonable step on our part to continue proper and responsible regulatory reforms. I look forward to consideration today and urge my colleagues to support it. And I yield back.
Chair thanks the gentleman, and now recognizes the gentleman from Georgia, Mr. Johnson, the ranking member of the Regulatory Reform Subcommittee, for his opening statement.
Thank you, Mr. Chairman. H.R. 3438, the Require Evaluation Before Implementing Executive Wish Lists Act of 2015, or the Review Act, would automatically stay high-impact rules that a party challenges. Simply put, this bill is yet another reckless measure designed to delay the implementation of the most important rules that protect public health, safety, and well-being of everyday Americans. This bill is completely unnecessary, and it puts public health, safety, and well-being at risk. So who does this legislation help? Well, corporate wrongdoers. Under current law, corporations affected by federal agency rulemaking already have the ability to stay implementation of rules promulgated by federal agencies. Both courts and the agency issuing a rule may stay the effective date of a final rule. While agencies have broad discretion in postponing the effective date of a rule, a court considers several factors in deciding whether to stay a rule, including whether the party is likely to succeed on the merits. In 2009, the Supreme Court in Nicken versus Holder instructed courts to consider 4 factors when deciding whether to issue a stay. 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether the issuance of the stay will substantially injure the other parties interested in the proceeding. And 4, where the public interest lies. The Review Act would discard this flexible test in favor of an inflexible and unyielding requirement that agencies automatically delay the effective date for any rule exceeding $1 billion in costs that is challenged in court, regardless of whether the party challenging the rule has any likelihood of success on the merits, is actually harmed by the rule, or whether staying the rule would be contrary to the public interest. It is virtually guaranteed that every high-impact rule would be delayed through litigation challenges, regardless of the merits of the litigation. This legislation would green-light frivolous litigation that would most certainly create years of delays for these rules to be implemented, which in many cases have taken years to promulgate. But the bill wouldn't just apply to life-saving rules that exceed $1 billion in costs, that keep our air clean and our children safe. Rather, it would likely apply to transfer rules, which would involve the transfer of funds for budgetary programs as authorized by Congress, such as transfer rules involving the Medicare program or the federal Pell Grant program, as the Office of Management and Budget has clarified. Lastly, Mr. Chairman, I oppose this bill because it is a dangerous solution to a non-existent problem. Any party affected by a final agency action may challenge that action in court, while agencies may also delay the effective date of rules on a discretionary basis. Professor William Funk, a leading administrative law expert, explains that existing law, quote, weeds out frivolous claims and takes account of both the cost of the rule and the benefits of the rule that would be avoided by granting the stay, end quote. Absent any evidence whatsoever that courts have inappropriately refused to grant stays, I'm confident that existing law provides adequate protection. I urge my colleagues to oppose H.R. 3438, and I yield back the balance of my time.
Chair thanks the gentleman. For purpose, the gentlewoman from California seek recognition.
To speak out of order about the passing of the former general counsel of the judiciary.
Without objection, the gentlewoman is recognized.
Thank you. I just wanted to take a moment before we get into this markup to remember Alan A. Parker, formerly the general counsel of the Judiciary Committee. He passed away last Friday after a long illness. He served as the legal assistant for my predecessor in office, Congressman Don Edwards, in the 70s, and then went on to become the general counsel for what was then a subcommittee for the Subcommittee on Civil Rights. He worked there for a number of years, and then after Jerry Ziefman, the general counsel, left, became the general counsel for the full committee, later was appointed a assistant attorney general. He loved the Judiciary Committee, and he loved the Congress of the United States, and served us very well. So he was served with distinction in the South Pacific during World War II. He was a wonderful man, and I wanted to remember him as we began this markup today and to mourn his passing. And I thank the chairman for allowing me to remember Alan A. Parker, late of the Judiciary Committee, in this manner. Thank you, and I yield back.
Chair thanks the gentlewoman and thanks her for reminding us about Mr. Parker and his long and distinguished service to the committee. And Chair recognizes the gentleman from Michigan.
Thank you, Mr. Chairman, and I join Zoe Lofgren in remembrance of Alan Parker, who I first met here when he was working for Peter Rodino, the chairman of Judiciary, when I came to the Congress. And what a person he was. He was very, very well remembered. He was personable, and he understood the law, and he realized how important the Judiciary Committee was. And those of us who had any contact with him will certainly hold him in high esteem and lament his passing. And I thank the chair.
Chair thanks the gentleman. Are there amendments to H.R.? Oh, sorry. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment to H.R. 3438 offered by Mr. Goodlatte of Virginia. Strike all that follows
Without
after.
objection, the amendment is considered as read, and I will recognize myself to explain. On November 3, 2015, the Subcommittee on Regulatory Reform, Commercial and Antitrust Law held a productive hearing on H.R. 3438, the Review Act. This substitute amendment refines and improves H.R. 3438 based on the expert feedback received at that hearing and further analysis of the bill. The amendment makes three principal changes. First, it adds language to make crystal clear that under the bill, agencies must submit new rules to the Office of Management and Budget's Office of Information and Regulatory Affairs for a determination of whether the bill may impose $1 billion or more in annual costs on the economy, and that the agency must publish that determination when it publishes the rule. Second, the amendment fine-tunes the bill's timing provisions. It makes sure that if a statute provides a period other than 60 days during which a rule may be challenged in court, the agency must provide that, if litigation is timely filed within that period, the rule will not be effective until the close of litigation. If no statute provides a different litigation filing deadline, then the bill's original deadline of 60 days applies to determine whether the agency must stay the rule pending the close of litigation. And lastly, the amendment provides a rule of construction to clarify that courts should not misinterpret the bill to limit their discretion to order judicial stays in cases involving less costly rules. The amendment strengthens the bill, and I urge my colleagues to support it. Are there any amendments to the amendment? I think I need to recognize the gentleman from Michigan first.
Thank you, Mr. Chairman. I merely want to point out that while this amendment makes marginal improvements to H.R. 3438, it doesn't mention or fails to address my overarching concerns about the bill. And indeed, by expressly specifying that the effective date of a high-impact rule is delayed until the final disposition of all actions seeking judicial review, the amendment encourages others to litigate even frivolous claims in order to delay the implementation of critical regulatory safeguards. Now, during the legislative hearing on H.R. 3438, Professor William Busby of Georgetown University Law Center said that the bill may have a devastating effect on the law while also creating massive economic and health harms and creating legal uncertainty. And he said that because it would ensure that high-stake rules will be challenged and under the terms of the bill, possibly delayed indefinitely. And so with these concerns in mind, I must restate my clear and unswerving opposition to this misguided legislation, and I thank the chair.
Are there any amendments to the amendment? For purpose of the gentleman from New York, seek recognition. Gentleman's recognized for 5 minutes.
Okay, Mr. Chairman, as I read I am constrained to disagree with the distinguished ranking member from Michigan who said that this manager's amendment makes a slight improvement to the bill. I think it makes it worse. As I read it, it says, an agency shall postpone the effective date of a high-impact rule of the agency until the final disposition of all actions seeking judicial review of the rule, instead of pending the end of judicial review. As I read that, what that seems to say is someone brings an action against the rule, it gets litigated for 5 years, the courts dismiss the action, and the day before the Supreme Court dismisses the action, someone else brings a new action. That gets litigated for 5 years. At the end of that period, someone else brings an action. And in fact, what this says is as long as someone doesn't like the rule and is willing to bring a new lawsuit against it, this isn't a temporary bar on the rule. This is a permanent bar on the rule, as long as anybody wants to litigate it. So if you have a rule that imposes some restrictions on some industry, on Wall Street or on any industry, and they don't like it, Company A brings the lawsuit, you wait a few years till that's almost finished. Company B brings the lawsuit, you wait a few years till that's almost finished. Company C, and there is never any time period in which this rule can go into effect, no matter the merits, no matter the cost-benefit analysis, no matter the judicial rulings. Every lawsuit gets lost. Every court says it's a valid rule, and it can never go into effect because there's always litigation pending. So I think that this bill, as amended by the manager's amendment, might as well simply be one sentence. No rule, and here's the one sentence, no rule with a cost of more than $1 billion to which anyone in the country objects shall ever go into effect. That's what it says. I contend that is irrational, wrong, and means that there'll be no rules ever. Maybe that's what we want. It's not what I want. It's not what I think the majority of the country wants. It's certainly not good for the health and safety and welfare of the country, but that's what this bill says as amended by the manager's amendment, and that's absurd. I yield back.
Would the gentleman yield?
Sure.
I would just like to address the gentleman's concern. It would be a legitimate concern if indeed that were the case with the manager's amendment in the underlying bill. However, Section 3B, failure to seek timely judicial review, provides that this cannot take place unless timely judicial review is sought. within the period explicitly provided for judicial review under the statute authorizing the making of the rule, or if no such period is explicitly provided for during the 60-day period beginning on the date on which the high-impact rule is published in the Federal Register. I thank the gentleman for yielding.
Reclaiming my time, as I read that, it doesn't, I looked at that carefully, at least as carefully as I could in the 2 minutes that we had this before I sought recognition. I don't think it says that. It says, if no person seeks...
Gentleman, yield. That's what I read from the amendment.
No,
That's
but
what-
I
it's
don't
what
think it
says.
means what you said. I'm going to go through it. Yes, you read the words, which I'm going to read too, but I don't think that's what it means. It says, if no person seeks judicial review during a period explicitly provided, or during the 60-day period, then the high-impact rule may take effect as early as the date. But if someone did seek judicial review, and then a few years later someone else again seeks judicial review, and then a few years later someone again seeks judicial review, and there's no time period at which judicial review is not pending, it can't take effect, and this language doesn't, I don't think this language cures that. This language simply says that the rule goes into effect if no one seeks judicial review in the initial time period. Someone sought judicial review in the ensuing time, in the initial time period, and then someone sought it again, and then someone sought it again. It meets the restriction in the bill, and it can never take effect. So I don't think that that cures it at all.
If the gentleman yield,
I'll yield.
it would be time barred by the statute, even if the gentleman's assumption of the reading were correct, which we definitely do not agree with. However,
Well, reclaiming my time, the statute, it could be 6 years. So maybe not indefinitely, but for a long time. Each litigation could take 6 years.
I'm gonna rely on the plain reading of the language. If the gentleman wants to offer an amendment, we'd certainly consider it. But I think the language is very clear that if you do not act
Well,
in the initial period of time, you're not going to be able to run out the refiling of statutes as you suggest.
Well, let me just say, I don't think that's what it says. I'm not going to offer an amendment to improve a bill that is terrible, even if this is not the case. And I trust that this bill will never become law.
Are there amendments to the amendment?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the Goodlatte Amendment in the nature of a substitute offered by Mr. Conyers. Page 1, line 17, strike and, page 1, line 19, insert after any rule the following, other than the expected rule.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on
I
his
thank
amendment.
the chair. This amendment, members, would exempt from the measure 3438 the act of high-impact rules promulgated by the Environmental Protection Agency that protect drinking water from lead and copper contamination. This is not hypothetical. This is real time. In my state of Michigan, in Flint, Michigan, the recent lead-contaminated water crisis that occurred there is only the latest in a long history of cases of contaminated municipal water supplies in many other places other than my state. Without question, the Flint crisis was a preventable public health disaster. The lead contamination occurred because an unelected and unaccountable emergency manager decided to switch the city's water source to the Flint River without the benefit of proper corrosion control. And as a result, corrosive water leached highly toxic lead from residents' water pipes, which thereby exposed thousands of children to lead, which in turn can cause permanent developmental damage. Now, while much of the blame for the Flint water crisis rests with unelected officials who prioritize saving money over saving lives, the presence of lead in drinking water is not unique to Flint. The drinking water of potentially millions of Americans may be contaminated by lead. In fact, elevated lead levels were detected earlier this year in drinking water supplied by, hold your breath, the Cannon House Office building. It's common sense that urgent rulemaking such as the EPA's proposed revisions lead to its lead and copper rule must not be imposed or delayed by measures such as 3438. Even before the Flint water crisis, the agency had begun the process of updating this rule, which was originally promulgated in 1991 after years of analysis. So rather than hastening this rulemaking, however, H.R. 3438 would ironically have the opposite result. Under the bill, an entity can delay such a rule for years through challenges, baseless challenges, that automatically stay the rule's effective date. Professor William Funk, a leading administrative law scholar, notes that, quote, H.R. 3438 would create an absolute incentive to anyone subject to the rule to challenge it no matter how unlikely success on the merits would be. Thus, totally frivolous claims could delay a high-impact rule for years. Urgent rulemakings, such as the Environmental Protection Act's Protection Agency's proposed revision to its lead and copper rule, must not be impeded or delayed by baseless challenges. It makes no sense to undermine the ability of federal agencies, such as EPA, to prevent future lead contamination crises as occurred in Flint. The Coalition for Sensible Safeguards, an organization I'm proud to acknowledge at this hearing, which includes more than 150 public interest organizations, strongly opposes this dangerous measure precisely for this reason, noting that it would add several years of delay to an already glacially slow rulemaking process, invite more rather than less litigation, and rob the American people of many critical upgrades to science-based public protections, especially those that ensure clean air and water, safe food and consumer products, safe workplaces, and a stable, prosperous economy. And so, my colleagues, I urge support for my amendment. And, Mr. Chairman, I yield back the balance of my time.
For purposes, gentleman from Pennsylvania seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
With all due respect, I oppose the ranking member's amendment. The Review Act applies to all new billion-dollar rules. That is for one simple reason: the harm that wasting billions of dollars is unnecessary compliance costs does to job creation, productive investment, and economic recovery. Those costs should not have to be incurred during ultimately successful litigation challenges for billion-dollar rules. And once again, this gets back to an issue that we seem to avoid on a regular basis. Congress wants to be involved in the legislative process, which we should be, and it's taking back our authority and our responsibility that over the last 30 or 40 years that Congress has given to the executive branch, and we see what that has cost us. Jobs, decline in unemployment, a decline in employment, the fact that it's putting businesses out of businesses. So once again, I urge my colleagues to oppose this amendment, and I yield back.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Seeing the chair, the noes have it. The amendment is not agreed to.
Chairman, I ask for a roll call vote.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Isa? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Ms. Walters? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Trott? Mr. Bishop?
Mr. Bishop?
Mr. Bishop?
Pass. Okay.
Mr. Bishop passes. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Pierre Luisi? Mr. Pierre Luisi votes aye. Ms. Chu? Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Peters?
Aye.
Mr. Peters votes aye.
The gentleman from Texas, Mr. Santo? The gentleman from Georgia? Gentleman from Michigan?
Mr. Bishop votes no.
The gentleman from Michigan, Mr. Trott?
Mr. Trott votes no.
The clerk will report.
I know, I feel bad that you have to sit next to me because I ask this question every time we do it. It's like, what is the point of doing this hearing? Like, it's not going anywhere. Like, why? Just for their donors?
Mr. Chairman, 11 members voted aye, 15 members voted no.
And the amendment is not agreed to.
Mr. Chairman,
For purpose of the gentlewoman from Texas, seek
I have an amendment at the desk.
Clerk will
I
report
think
the
it's
amendment.
listed as amendment number 3 from
Amendment to the Goodlatte Amendment in the nature of a substitute offered by Ms. Jackson Lee of Texas. Page 1, line 17, strike and, page 1, line 19, insert after any rule the following other than an expected rule. Page 2, line 2, strike the period and insert and, page 2, insert after line 2 the following.
The gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. Ebola, West Nile virus, Zika virus are all very present and current in the minds of Americans among the many other potential infectious diseases or public health emergencies. One might consider the 500,000 persons, I believe the number is, that have been impacted by the Baton Rouge floods as also in a health emergency. Health emergencies arise across America on a constant and regular basis. And so I would offer the Jackson Lee Amendment to exempt from H.R. 3438, the Review Act, any rule promulgated to prevent, respond to, or mitigate the adverse impacts of public health emergencies like the outbreak of the Zika and Ebola viruses. Let me say to my colleagues, as I've often listened to our senior member, Ranking Member Conyers, on his lifelong experience, apparently I've served long enough to remember something like the Review Act coming up every year. And so I would offer to say, here we go again. H.R. 3438, as currently drafted, is an unnecessary and misguided bill that can dangerously hamper our nation's efforts to respond to public health emergencies, among many other public policy measures needed to provide public protections. As it is presently written, it requires agencies to postpone until the completion of judicial review the effective date of any new regulation that imposes $1 billion or more in cost on the economy if litigation challenging the regulation is brought within 60 days of the regulation's publication in the Federal Register. Now, cost is a relative issue, and I believe that the bill is speculative enough that one might suggest that someone may have a lawsuit dealing with any decisions being made dealing with a public health emergency that would rise to the level of $1 billion. Maybe it is a pharmaceutical challenge and litigation, but it is a public health emergency. In particular, H.R. 3438 seeks to address concerns associated with rules that may be overturned by courts by halting or stalling billion-dollar regulations until the legal proceedings concerning their legitimacy and cost have concluded. Let me clarify that. Regulations are not billions of dollars, but the potential of a lawsuit that may generate that amount of cost. That should not be the consideration in a public health emergency. And so this is legislation is particularly problematic. My amendment would ensure that the federal government is not further prohibited from responding to emergencies such as the Zika virus epidemic and other public health crises. According to the Coalition for Sensible Safeguards, Congress should be looking for ways to strengthen our nation's regulatory system by identifying gaps and instituting new science-based safeguards for the public. I cannot agree more, as we are now in perilous times where the Zika virus presents unprecedented threats to the people of our nation. We're well aware that each child that may be impacted by the Zika virus, meaning a mother who is pregnant and impacted, that a child is impacted by the Zika virus, if they are born with microcephaly, they are apt to cost $10 million, and that's at a minimum. Thus far, there have been more than 16,800 cases of Zika infection reported to the Centers for Disease Control and Prevention in U.S. and its territories, including more than 2,700 on the mainland. Over 1,500 women have been infected, and there have been 17 confirmed cases of babies born with birth defects. So I would argue to my colleagues that this is nothing to play with. I offer to introduce into the record the letter from the Sensible Coalition for Sensible Safeguards, dated September 7th. I ask unanimous consent to the chairman. Washington Post article, CDC and NIH officials dealing with the Zika virus and highlighting the cost of how much it will cost to take care of a child during their lifetime. Again, those are speculative dollars. And then I asked for a portion of the whitehouse.gov website regarding the Zika virus and the importance of vaccine research, diagnostic development, mosquito surveillance, and mosquito control. Let me conclude my remarks. I ask unanimous consent for all these to be put in the record, Mr. Chairman. And let me
Objection, they will be made a part of the record.
Let me just quickly conclude my remarks by saying Texas thought that this was so crucial an issue, and as I see my colleague from Puerto Rico, that we organize a regional Zika prevention task force. Our leading health professionals from the state, Republican state government, from the counties and cities. And then, of course, Dr. Peter Hortez, a renowned infectious disease specialist from Baylor College of Medicine, has indicated we can't wait. I don't think a passage of this legislation that may in fact undermine working on emergency issues is the best direction. I ask my colleagues to support the Jackson-Lee amendment. I yield back.
For the purpose of the gentleman from Pennsylvania, seek recognition.
Move to strike last word.
Gentleman's recognized for 5 minutes.
If rules like those, the amendment would carve out are needed, agencies can avoid the bill's application by coming up with effective regulation that costs less than $1 billion a year. That is a goal to be pursued, not blocked. If, in an unusual case, the needed solution truly must cost $1 billion a year or more, then the decision to adopt that solution is a decision Congress should make, not an agency. Congress, moreover, can make that decision without hindrance of litigation, through fair and open consideration and debate by the people's representatives, not an unaccountable bureaucrat. And I yield back.
Question occurs on the amendment offered by the gentlewoman from Texas. For the purpose of the gentleman from Puerto Rico, seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
I rise in support of this amendment, and I just want to appraise my colleagues here and actually make sure that the congressional record reflect that the Zika emergency is not any emergency, is not any public health crisis. It is a major public health crisis. In the case of Puerto Rico, you're talking about 16,537 laboratory-confirmed cases of Zika. Each of Puerto Rico's 78 municipalities is affected. Approximately 98% of locally acquired cases in the United States are in Puerto Rico, according to the CDC. There are locally acquired cases in Florida, 35 of them, USVI, 221, and American Samoa, 47, and this is just starting. 1,384 pregnant women diagnosed with Zika in Puerto Rico. 132 people hospitalized due to Zika. 3 fatalities of individuals who tested positive for Zika, but officials unable to conclusively cite Zika as the cause of death. 31 cases of Guillain-Barré syndrome caused by Zika. On August 12, 2016, Health Secretary Sylvia Burwell declared a public health emergency for Puerto Rico. The declaration is an administrative tool that provides flexibility for health officials in Puerto Rico to address the outbreak on the island. Through the Public Health Emergency Declaration, the government of Puerto Rico can apply for funding to hire and train unemployed workers to assist in vector control and outreach efforts, and request temporary reassignment of local public health department or agency personnel who are funded through Public Health Service Act programs in Puerto Rico to assist in the Zika response. So, and this is again just starting. It is really unfortunate that Congress hasn't approved a supplemental emergency bill for this purpose. You all should remember that Puerto Rico is a U.S. territory. We don't need passports to travel from Puerto Rico to the States. There's migration all the time, travel all the time. Women are exposed, particularly. Unborn children and children are particularly exposed. So this amendment is well taken, is well thought out, and I urge my colleagues to make this exception. Zika, again, merits an exception.
Would the gentleman yield?
I do. I yield.
I thank the gentleman for making this important point, and I'd like to just add that this bill would delay any high-impact rule for the duration of all legal challenges regardless of merit. And alarmingly, the bill has absolutely no exception for rules issued to prevent or respond to a public health crisis. And so, in the words of one professor, the bill displaces a body of law long developed by the Supreme Court while allowing any litigant to delay rules that allow a huge risk to the population or to the environment. And I thank my colleague for yielding.
Chairman,
The gentleman from California seek recognition.
to strike a last word.
Gentlewoman's recognized for 5 minutes.
I'd like to speak in favor of this amendment. I think there are other instances where there should be exceptions, as the ranking member has pointed out, but really none is more clear than the Zika emergency, which my colleague, Ms. Jackson Lee, has pointed out with her amendment. We know that as the science develops, that this disease not only attacks the brains of babies, leading to microcephaly and severe impacts on intelligence and capacity, but also apparently affects infants later on, even if they don't show signs of developmental disorders at birth. So this is a very devastating disease for families. It's been estimated, an estimate I heard yesterday was that for those children who actually survive, it will be at least a $2 million expense to care for them and their severe disability until they do die at an early age. So we need to do everything we can in terms of funding vaccines, taking emergency steps, and this bill, I think, would disrupt those efforts. So I would hope that even though we might disagree on the entire measure, that we would support this amendment, and I would like to yield to the gentlelady from Texas for further comments.
Let me thank the gentlelady, one, for her astute comments, but also let me take a moment, Mr. Paralisi, to thank you for your leadership on many issues dealing with Puerto Rico, but knowing how hard you have fought to provide those resources necessary to provide those distinguished citizens in Puerto Rico. Let me just add to the comment that there is an element in the language that speaks about 1 billion. The bill defines a high-impact rule as any rule that the administrator of the Office of Information and Regulatory Affairs determines may impose an annual cost on the economy. Public health emergencies, by their very definition, are costly to save lives. I ask my colleagues to support the Jackson Lee amendment. I yield back.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. Record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Isa? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold?
No.
Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Ms. Walters? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Trott? Mr. Trott votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi?
Aye.
Mr. Pierluisi votes aye. Ms. Chu? Ms. Chu votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Peters?
Aye.
Mr. Peters votes aye.
The gentleman from Florida.
Mr. Deutsch votes aye.
As every member voter who wishes to vote, clerk will report. Clerk will report.
Mr. Chairman, 14 members voted aye, 14 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 3438?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the Goodlatte Amendment in the nature of a substitute offered by Ms. Del Bene. Page 1, line 17, strike and. Page 1, line 19, insert after any rule the following. Page 2, line 2, strike the period and insert and. Page 2, insert after line 2 the following. The term expected rule means any rule that would increase college affordability.
The gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. As everyone in this room knows, the rising cost of college is posing serious challenges to students and their families. Every year, Americans are being forced to take out higher loan amounts to pay for tuition, fees, textbooks, and housing. And today, student debt totals more than $1.3 trillion. In my home state of Washington, 56% of graduates from four-year universities leave school with debt. And on average, those students owe more than $23,000 upon graduation. At a time when Americans owe more in student loan debt than credit card debt, it's more critical than ever that we prioritize college affordability for all. And this issue is very personal for me. When I was young, my father lost his job and my parents never got back on track financially. But thanks to student loans and financial aid, I was able to get a great education. And because of education and hard work, I was able to build a successful career and eventually to be in the position that I am today. We need to make sure today's students have the same opportunities that were available to us. That starts by protecting the Department of Education's ability to administer vital financial aid programs like Pell Grants and federal student loans. These programs have enabled millions of low-income students to attend college. If we restrict the department's ability to administer them, we're also endangering millions of hardworking Americans who rely on this critical support. This year alone, more than 8.4 million low-income students will benefit from Pell Grants. Over 20 million student loans will be issued to help students and parents afford the cost of college. We cannot put these essential resources at risk. They help ensure higher education is never out of reach, and they must be protected. That's why I'm offering this straightforward and narrowly tailored amendment. It simply protects the administration's ability to administer federal student aid programs that keep college affordable and accessible to all. Today, too many families are struggling to put their kids through college, and we should be making it easier for them, not harder. My amendment will prevent the underlying bill from threatening the vital assistance offered each year through Pell Grants, student loans, and other forms of federal financial aid. Particularly as students are heading back to school in communities across the country, I urge my colleagues to support this important amendment. Thank you, and I yield back.
For purpose, the gentleman from Pennsylvania seek recognition.
Move to strike last word.
Gentleman is recognized for 5 minutes.
I totally agree with my colleague on the education issue. My family could not afford to send me to college. In fact, I didn't go till I was 30, and my wife and I put me through college. Unfortunately, I think, and one of my degrees is in secondary education, so it's very important to me. I disagree that this is the mechanism to do that. I would like to work with you on a standalone bill that specifically addresses that issue because of our how deeply we believe in education is the key to one of the successes in this country. But I have to respectfully disagree that this is a mechanism to do that. Congress has to take back its authority that we've given to the presidents over the decades. But again, I reiterate, I would really enjoy working on a piece of legislation that it's a standalone and addresses these issues as far as loans, because I never would have been able to go through college if it weren't for those loans. And I yield back.
Mr. Chairman,
For purpose, the gentleman from Rhode Island seek recognition.
move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I seek recognition to speak in strong support of this amendment. The federal Pell Grant program, named for United States Senator Claiborne Pell, who represented my home state of Rhode Island in the United States Senate, is one critical way to open doors and doorways of opportunity for more than 8 million low-income students who receive financial aid to pay for tuition, books, and room and board each year. In 1965, Senator Pell helped lead the effort in Congress to expand financial aid for at-need college students through the Higher Education Act. When President Johnson signed this bill into law, he remarked that the bill would, quote, swing open a new door for the young people of America. For them and for this entire land of ours, it is the most important door that we will ever open, the door to education. And this legislation is the key which unlocks it, end quote. H.R. 3438 would allow any party to delay the effective date of any high-impact rule, regardless of substance, through frivolous claims. High-impact rules typically involve either the transfer of federal funds or rules with billions of dollars in benefits to the public. During fiscal year 2014, for example, executive branch agencies adopted 53 major rules, 35 of which were transfer rules. According to the Office of Management and Budget, transfer rules merely implement federal budgetary programs as required or authorized by Congress, such as rules associated with Medicare, the Medicare program and the federal Pell Grant program. While these rules do not involve substantive rulemaking so much as the transfer of federal funds as required by Congress, this bill, H.R. 3438, provides no limitation on challenges to these rules. Any party that files a claim challenging the transfer of these funds would automatically postpone the transfer of these funds. The costs of delaying these highly beneficial rules could be devastating, particularly for students. For example, a person that's unhappy with their tuition assistance could challenge the transfer of funds under the federal Pell Grant program, thereby delaying the transfer of tuition assistance to every student nationwide for an untold period of time. As Professor William Funk, a leading administrative law expert, has noted, even frivolous claims that could delay high-impact rules for years while costing the nation billions in dollars annually. According to the Nonpartisan Congressional Research Service, the federal Pell Grant program is the single largest source of federal grant aid supporting post-secondary education students. It provides millions of low-income students with an opportunity to attend college through financial assistance. Without this assistance, college attendance is impossible for these students. Delaying this program would adversely harm low-income communities and contribute to the growth of income inequality. The social and economic impact of an affordable education for these students is impossible to quantify. It's critical to jobs, to the growth of our economy, and to closing the income gap. This amendment is critical, and I applaud my colleague, Congressman Del Bene, for offering it. It's really critical to avoiding financial catastrophe for our nation's students and their families, and I strongly urge my colleagues to support this amendment and yield back the balance of my time.
Question occurs on the amendment offered by the gentlewoman from Washington. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, I ask for a recorded vote.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe, Mr. Chaffetz, Mr. Marino. Mr. Marino votes no. Mr. Gowdy, Mr. Labrador. Mr. Labrador votes no. Mr. Farenthold. Mr. Farenthold votes no. Mr. Collins. Mr. Collins votes no. Mr. DeSantis. Ms. Walters. Mr. Buck. Mr. Buck votes no. Mr. Ratcliffe. Mr. Ratcliffe votes no. Mr. Trott. Mr. Trott votes no. Mr. Bishop. Mr. Bishop votes no. Mr. Conyers.
Aye.
Mr. Conyers votes aye. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Pierluisi.
Aye.
Mr. Pierluisi votes aye. Ms. Chu. Ms. Chu votes aye. Mr. Deutsch. Mr. Deutsch votes aye. Mr. Gutierrez. Ms. Bass. Mr. Richmond. Ms. Del Bene. Ms. Del Bene votes aye. Mr. Jeffries. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Peters. Mr. Peters votes aye.
The gentleman from Iowa? The
Mr.
gentleman from Ohio?
Mr. Jordan votes no.
The gentlewoman from California?
Ms. Bass votes aye.
The gentleman from New York?
Mr. Jeffries votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 14 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments? For purpose, the
Aye.
gentleman from Rhode Island seek recognition.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the Goodlatte Amendment in the nature of a substitute offered by Mr. Cicilline. Page 1, line 17, strike and.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would exempt rules that reduce the cost of health care for Americans over the age of 65 from the unnecessary requirements of this legislation. Our country's seniors face growing health care costs, and any delays in rules that could reduce those costs would be a terrible burden to place on our seniors. According to the latest retiree health care cost estimate from Fidelity Benefits Consulting, a 65-year-old couple retiring this year will need an average of $260,000 in today's dollars to cover medical expenses throughout their retirement. That applies only to retirees with traditional Medicare insurance coverage and does not include costs associated with nursing home care. Fidelity estimates that a 65-year-old couple would need an additional $130,000 to insure against long-term care expenses. The median annual cost for the base rent at an assisted living community is about $41,000 a year. The average annual cost for skilled nursing is about $71,000 a year. Because much long-term care is provided by unpaid family caregivers or is covered by Medicaid, the average senior's lifetime out-of-pocket long-term care expenses are about $50,000. And so you can see from these very large figures that delaying the imposition of any rules designed to bring down these already very high costs for our seniors would impose a serious hardship on American seniors. This legislation would open up in the rulemaking process to a lengthy delay, often allowed by companies or entities who are opposed to certain rules to take advantage of the court system to stymie final rulemaking for years. Our seniors don't have years to wait on policies that could save them precious dollars in their retirement. There's already a robust process in place for opponents of rules to challenge them in court, with the decision whether to delay a rule rightly placed in the court's hands. This legislation is a gift to the special interests who wish to spend millions and waste years fighting regulations that could benefit the American people, and particularly America's seniors. High-impact rules typically involve either the transfer of federal funds or rules with billions of dollars in benefits to the public. And as I mentioned earlier, during fiscal year 2014, as an example, executive branch agencies adopted 53 major rules, 35 of which were transfer rules. According to the Office of Management and Budget, transfer rules merely implement federal budgetary programs as required or authorized by Congress, such as rules associated with Medicare and the federal Pell Grant program, end quote. There are 44.9 million seniors on Medicare in this country. Allowing frivolous lawsuits to delay their benefits or reduce the cost of their health care would be a grave betrayal of the promise we've made to keep America's seniors healthy. My amendment would simply ensure that any rule that reduces the cost of health care for Americans 65 or older will not be subject to unnecessary delay that our seniors cannot afford. I urge my colleagues to support this amendment, and I yield back the balance of my time.
For purpose, the gentleman from Pennsylvania seek recognition.
Move strike last word.
Gentleman is recognized for 5 minutes.
Once again, the Review Act applies to all new billion-dollar rules. However, that is for one simple reason. The harm that wasting billions of dollars as unnecessary compliance cost does to job creation and productivity investment. This is a responsibility of the Congress, separation of powers, and Congress can deal with these issues once brought to Congress, just like we did on the Zika issue. And I want to raise something up on the Zika issue. The House passed the Zika bill. The House and the Senate initially agreed on Zika at $1.1 billion. The president said he was going to veto it, and the Democrats in the Senate changed their mind because they wanted more spending on it. So if you were so concerned about having money to fight Zika like we did in the House, and the voting was along party lines, I voted for it. Almost every Republican voted for it, and I think 3 Democrats voted for it. Why not take that money and then address the issue later on where we needed more money? That's the hypocrisy I see here. But as far as my colleague and my friend Mr. Salini is addressing the issue, again, as I stated to Ms. Delbeni, I think there's another, there should be another venue for that.
Would the
And
gentleman
I will
yield?
work with you on these issues.
Would the gentleman yield?
Gentleman yield to a
Yes, sir.
question?
Yeah.
I think it's important to understand that this is, the Zika money you're speaking about is money that hasn't yet been allocated. In this instance, this bill would in fact speak about money that's already been allocated, transfers that are just executing what Congress authorized. So it's quite different. Your Zika example is money that hasn't yet been allocated. This bill that we're currently considering, those transfers are already for allocations that have been made. That's the difference.
You say that the transfers have made, but as far as the Zika bill is concerned, you say money's not been allocated. That money would be allocated almost immediately. It wasn't allocated given the fact that Democrats in the Senate changed their mind and didn't agree what they agreed to initially. As far as your legislation is concerned, I would love to talk with you on this matter, fully expand it at a later time, as we have on other
Would the
legislation.
gentleman yield? Would the gentleman yield?
Yes, I will.
Wasn't it, it's always been my assumption when you have an emergency that you need an appropriation for, you appropriate X dollars for that emergency. Is my recollection correct that the Senate bill, which the Democrats refused to accept, put in 2 poison pill amendments on Planned Parenthood funding and on, what was the other one?
Confederate flag.
And on the Confederate flag?
Yielding
And
back
that
my
was,
time.
and that was the
Yielding back my
cause
time.
of
That was a deviation from the original agreement between the House and the Senate. And then that's when that changed, as far as I recollect on what I.
the original agreement had
House
nothing
and
to
the
do with
Senate-
that?
The House and the Senate agreed on the $1.1 billion, and it was supposed to be passed. Then the Senate backed out of it. The president said he was going to veto it because there wasn't enough money. Now, you can always come back and
Not
ask-
because of
ask
these
for
other
more
2
money.
amendments?
Excuse me?
Not
Not to my
be-
knowledge.
My recollection is that the problem was that there were two amendments that were, in effect, unrelated that people couldn't accept, or some people
And
couldn't
my
accept.
recollection is not originally.
Mr. Nadler, would you
Will the
yield?
gentleman yield? Will the gentleman yield over here?
Yes, I'll yield.
So I think it's this gentleman's
Who
time.
has the
Actually, I
time?
think it's my
Actually, you have the
time.
time.
I'm behind you
It's my
over
time,
here.
and yes, I will yield.
Thank you. I appreciate the gentleman
next.
yielding. I think the gentleman from Pennsylvania is making a very valid and important argument, and you can bring up language such as poison pills and that kind of thing. That's not, the bottom line was, the House acted. The media basically ignored this over the last couple of months that we have been up here, but the bottom line is the House passed legislation which would have funded fighting Zika, which we all want to do. The problem was, the president wanted to spend more, so if we wouldn't spend more, he wouldn't spend anything. And the other problem was, we don't think we ought to be funding Planned Parenthood and something like fighting Zika, and they didn't want that. We wanted to pay for this thing, and that's what we did in our bill. So the House acted responsibly. We voted sufficient money to fight Zika and to pay for it, and not to fund Planned Parenthood. But that wasn't good enough for the other side. They wanted more money. They wanted the money to go to Planned Parenthood, and they didn't want to pay for it because they don't care about a $19 trillion deficit that we have. So I think the gentleman from Pennsylvania is making absolutely valid points, and all this business about poison pills and all that is a bunch of baloney. And I thank the gentleman for yielding.
I think my time has expired.
Time
Not
of the
sure.
gentleman has expired. For purpose of the gentleman from California, seek recognition.
To strike the last word.
Gentlewoman is recognized for 5 minutes.
I listened carefully to the comments made about Zika funding, and obviously people have a different perspective on it. Just a point about birth control. You know, there is a reason why birth control is important when you have an epidemic of Zika. People are afraid to become pregnant if they're exposed to Zika because their baby is going to be brain dead. And so the two are related, and preventing birth control funding is a serious problem when it comes to Zika. I just think somebody needs to make that point. In terms of, you know, poison pills, non-poison pills, I didn't think the Confederate flag had much to do with Zika, in all honesty. But here's the deal. I was in local government for a long time before I was in the Congress. And what we did was we authorized the Public Health Department to take certain steps to deal with a public health emergency. Some of it's money, but some of it is taking certain steps to prevent people from being exposed and the like. And to say that those types of regulations, if you want to call them that, would have to be subject to this very, you know, lengthy procedure is completely at odds with what you need to do in a public health emergency. There is a role for administrative action when dealing with a very serious public health emergency. And just, I'm going to yield to my colleague, the gentlelady from Texas, in a minute. But the fact that here we are, it's mid-September, the scientists at CDC asked the Congress to appropriate money last spring. And here we are, there's no money that's been appropriated. We could argue about who's right, who's wrong, but the fact is, there's no money. And we have an outbreak that is serious and getting more serious, and we have not been able to act. So that we would further prevent the public health officials from acting is even more irresponsible than our failure to appropriate funds. It's the argument we're having here is further evidence of why this procedure should never be addressed and applied to a public health emergency such as Zika. And I'd be happy to yield to my colleague from Texas.
Thank you very much, Congresswoman, and you're absolutely right. Both of us came from local government, you from county government, mine from municipal city government. And I would just make the point that this whole legislation undermines. This is an emergency. One of the things that I think that Congresswoman was saying is that in local government, you just act. You have to act. You're closest to the people. And that is what's happening in states like Texas and Florida, and it'll probably be in California and really across the nation, is that the local governments will have to act. They're acting in mosquito control. They're acting in health clinics trying to assess the fever and rash syndrome of individuals, as whether it's Zika. They're dealing with sexually transmitted situations, and they're dealing with pregnant women. And so there is no question that the threshold or the floor of this legislation indicates $1 billion. I would just offer to say that we need to do more. May I just put into the record, by unanimous consent, Sheila Jackson Lee, How to Fight Zika and Cure Nation's Ailing Public Health System in the Time magazine. I yield back.
Without
Reclaiming,
objection, will be made a part of the record. For purposes, gentlemen from...
reclaiming my, do I have any additional time? I wanted to reclaim my time and just make this final point. The representative from Puerto Rico has very eloquently made the case for the serious situation in Puerto Rico. Certainly our colleagues from Florida have raised the alarm. But take a look at the map of where the mosquitoes reside. There are 2 mosquitoes that carry this. It's my district, it's the Midwest, I mean, it's most of the United States. So to think that this is not going to impact most of the United States is a mistake. And because this is a disease that's also sexually transmitted, this is going to impact all of our country and potentially all of the world. So I would hope that Ms. Jackson Lee's amendment did not pass, but I hope that we could keep these issues in mind as we proceed further, and I yield back.
Mr. Chairman.
For purposes, the gentleman from Wisconsin.
Chairman, I move to strike the last
Gentleman's
word.
recognized for 5 minutes.
Mr. Chairman, my friends on the other side of the aisle are very good at either trying to rewrite history or forgetting what's happened. And I'm sorry that they've taken that position. The House of Representatives has done its job on Zika. We have passed a bill that funds the national fight against the Zika virus. It's over in the other body now. And there have been at least 3 cloture votes over there that have failed. And who didn't want to bring the bill up and voted against cloture? It's the soulmates and party mates of the people over on the other side of the aisle. Now, I would suggest, rather than putting amendments in like this to a bill, is that we pass this bill and we deputize my friends over on the other side of the aisle to go and cross the Capitol and say this is an emergency, which it is, and they ought to vote to bring the bill up and pass it and send it to the White House. We thought they had made an agreement on that, but evidently the agreement in the Senate didn't stick. So let's get on and reject this amendment and pass this bill, and then maybe the honorable senators will give you folks lunch where you talk about this issue and its urgency. I yield back.
Mr. Chairman.
For purposes, the gentleman from
Idaho.
Tennessee seek recognition.
Thank you. Just strike the last word.
Gentleman's recognized for 5 minutes.
I may be confused about some of this. Mr. Moreno's my good friend, and I'm kind of, all this Zika funding, and if you would, you may know, Mr. Sensenbrenner may know, I don't know. Didn't this have something to do when we finally passed it with honoring with Confederate flags the folks that went up into Pennsylvania and came close to your farm and tried to invade your country and my country and our country and all that kind of stuff? What's that got to do with Zika?
Well, first of all, no, that's not my understanding. And as far as Pennsylvania's concerned, they know better than to come into our district and carry on like that.
I like it when
we're
Alabama used to.
We're NRA guys.
I liked it when Alabama went up to play Penn State.
Not in 1863,
but I don't
right.
think it was really necessarily the same deal during the Gettysburg, and I think it was in there, Ohio too, that we had to put flags of the Confederacy on the graves at the federal cemeteries,
Well,
and that was
if my friend
kind of
would,
the bad guys.
if my friend would yield for a moment, and I agree with what Mr. Sensenbrenner said. We did our job, and the 3 or 4 of the Democrats that voted for this. It's on that other side.
we
So
did our
maybe you and I can go over there and knock some sense into their heads.
Gentlemen yield. Would
I
the
think
gentleman
we'd be
yield?
more likely to get a statue of Joe Namath to replace Joe Paterno, and that would be more likely to have
Would the gentleman
success.
yield? Would the gentleman yield?
My recollection is the bill that passed the House, number 1 was only for $600 million, not the 1.6 that was necessary, and 2, took the money from Ebola, which is still a major public health problem, And so is robbing Peter to pay Paul. I yield back to the gentleman.
Peter and Paul, do they play for Penn State or Alabama?
Oh, and would the gentleman yield again?
I yield.
I also wanted to point out that back in 1863, it was not the NRA, it was the Union Army that turned back the invasion of Pennsylvania. I yield back.
I yield back before this gets too far.
What purpose does the gentleman from Idaho seek recognition?
To strike the last word.
Gentleman from Idaho is recognized for 5 minutes.
Mr. Chairman, this is pretty frustrating. As the only Republican who voted for the amendment of Ms. Jackson Lee, this debate is verging on the ludicrous and the ridiculous. We passed a bill out of this Congress, out of this House, that funded the problems that we have in Puerto Rico, that funded the problems that we have in Florida, that funded the problems that we have in Texas and all of these different states that are being affected by the Zika virus right now. We funded it fully, and unlike what was just said, which continues to be the misrepresentation of the other side, we funded $600 billion plus we used money from Ebola to fully fund the problem that we have in the United States. The Democrats have been nothing but irresponsible on this issue in the Senate. And if you don't like the amendment that passed on the Confederate flag, remove it in the Senate and pass a damn bill. That's all you need to do. Stop complaining about it, do your work, and stop using people's lives as an issue so you can advance your agenda on abortion. I'm sick and tired of it. Get it done, stop complaining, go to the Senate, and do your job.
What purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman recognized for 5 minutes.
Thank you, Mr. Chairman. To set the record straight about Zika funding, back in February, back in the winter, when this Zika crisis, this public health crisis was foreseeable, it was right there in front of us, and President Obama asked Congress to allocate $1.9 billion to deal with this public health emergency that was then looming. What happened was the Senate took up a bill 2 or 3 months later, and they passed a clean spending bill, an emergency spending bill for $1.1 billion. It was below what the president offered or asked for, but it was a clean bill. And they passed it in the Senate and sent it over here to the House of Representatives. The House of Representatives sat on the bill for a little while longer as the crisis began to get closer to us. It finally passed a $600 million bill, but that bill had poison pills in it. For the umpteenth time, that bill sought to defund Obamacare and also Planned Parenthood. It was unacceptable to Democrats who voted against it, but the House passed it. And then what happened?
Gentlemen, yield.
And then what happened was the House
yield.
and the Senate, both controlled by members of the opposite party, decided to go on a 7-week vacation. And during that 7-week vacation period, the heat of the summer, the mosquito time of year, 17,000 people in America have been infected by the Zika virus. 1,700 pregnant women are infected. 200 kids have been born with microcephaly, which will impact taxpayers at the tune of about $10 million for the life of each of those youngsters. It's a public health crisis. People are, pregnant women are afraid to be bitten by mosquitoes. This House has now been back in session for a week. The Senate has been in session for a week, still playing games with the Zika public health emergency. And it's really time for us to stop putting poison pills into Zika funding bills. Let's just pass, if you're serious about dealing with this public health emergency, let's just pass a clean Zika funding bill, even if it's the paltry $600 million that this House passed. That's better than nothing, because the CDC, as of about 2 weeks from now, will be out of money to address this issue, which it has been transferring money from the Ebola Fund, from other public health funds to deal with this sudden emergency. And everybody knows it's an emergency except for the members on the other side of the aisle, the Republicans here in Congress. Everybody knows that it's an emergency, but the Republicans in control of both House and Senate refuse to pass clean emergency spending bills without poison pill pay-fors, so that we can deal with this issue that affects women and children, and ultimately all of the men in this country are impacted. And so let's stop playing games with this, political football. I'll yield to the gentleman.
Hey, just a couple questions. I appreciate the gentleman yielding. In which House is the Zika funding bill currently pending?
Sir, I'm not going to
well, I'll answer it. It's
I'm
the
not going
Senate.
to get into a dispute
And
with you.
and which side is filibustering
I'll
in the
reclaim-
Senate? Your side of the aisle.
I'll reclaim my time.
Let's pin the tail on the donkey, sir.
I reclaim my time and stick by everything that I have said, and if anybody wants to refute it, they are free to move to strike the last word and deal with what I have said.
For purposes, the gentleman from Texas seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
I yield to my friend, Mr. Labrador.
I don't remember, Mr. Chairman, whether the Senate passed a bill or not, but assuming that they did, we have in the Constitution a process where both sides can actually go to conference. And that's not what you're asking for. You're asking for a political victory. You're asking for things that are not going to happen. Let's go ahead and go to conference. I don't remember the Senate. I want to see that bill because I don't remember the Senate having actually passed a bill. But if they did, we have a House bill, we have a Senate bill. Our Constitution allows us to go to conference, and you can remove the things that you don't like about the bill, and we can move forward. But this political posturing that your side has been doing for the last 7 weeks on this bill, when the only side that has acted on this issue is the Republican side in this House, I'm sick and tired of it.
Will the
And I
gentleman
will
yield?
not stand for it anymore, and I will not yield. I will yield to the gentleman from Mr. Sensenbrenner.
Well, I thank the gentleman for yielding. This discussion very clearly points out where the roadblock is in getting a Zika bill passed. It is not in the House of Representatives. It is in the other body. And a Republican majority leader in the other body has made at least 3 motions to bring that bill up so that the other body can act on it. And guess what? Each of the 3 times, Mr. Johnson, or the gentleman from Georgia's party mates over there, have filibustered the bill. There is a Democratic filibuster against Zika funding that is going on in the United States Senate. And there is going to be no progress on an emergency bill that all of us on this side of the aisle recognize until that Democratic filibuster stops. Now, I'd just like to hasten back to just before we broke for the recess. We had the same argument about funding the opioid bill, and I was the principal sponsor of the House version of that. And we heard all of this huffing and puffing, and the House didn't blow down. And finally, the House Democrats decided that, yeah, there was an opioid emergency, withdrew their objections, and the opioid bill passed with just a handful of dissenting votes. Now, that can be done again on the Zika funding bill, but it's not being done, not because of anything that House Republicans or House Democrats or Senate Republicans are doing. It is because of the Democrats conducting a filibuster in the other body. It strikes me as being very, very similar to the filibusters that Southern Democrats did 50 years ago against civil rights bills. Now, fortunately, they passed because there were enough Northern Democrats that woke up and knew that these laws were necessary. Now, maybe there will be enough Democrats that wake up and decide to stop filibustering over in the other body, and we can get this bill either to and through conference or go right to the president's desk. You know, I agree with the gentleman from Georgia that $600 million is better than nothing. But it seems to me that there are a lot of people who are filibustering over in the Senate that would rather have a political issue than $600 million or $1.1 billion or $1.6 billion or $1.9 billion or whatever number is better than zero. So again, it's getting to be lunchtime over in the Senate, and let's wrap this up so that my friends over on the other side of the aisle can go over, have their senators take them out to lunch, and tell them to withdraw their filibuster and get a move on. And then I thank the gentleman from Texas
Would the
for
gentleman
yielding.
yield?
And may I?
The rest of my 40 seconds.
And pretty simple, what the Democrats in this committee can do is walk from here to the Senate, tell them to stop the filibuster. They can offer an amendment to remove the Confederate flag issue. I'm sure the Senate will approve that amendment, and we can pass the bill, and we can stop the political games. And I yield back to my friend.
The chair recognizes himself for the purpose of reminding the members that in the midst of this enthusiastic debate, the debate should be focused on the amendment of the gentleman from Rhode Island, Mr. Cicilline, and the underlying bill, and my substitute amendment to that bill. So, the question occurs on the amendment offered by the gentleman from Rhode Island, Mr. Cicilline. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
That's for a recorded vote, Mr.
Recorded vote
Chairman.
is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Isa? Mr. Isa votes no. Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? No. Mr. Farenthold votes no. Mr. Collins? No. Mr. Collins votes no. Mr. DeSantis? No. Mr. DeSantis votes no. Ms. Walters? Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Mr. Trott? No. Mr. Trott votes no. Mr. Bishop? No. Mr. Bishop votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Aye. Mr. Cohen votes aye. Mr. Johnson? Aye. Mr. Johnson votes aye. Mr. Pierluisi?
Aye.
Mr. Pierluisi votes aye. Ms. Chu? Ms. Chu votes aye. Mr. Deutsch? Mr. Gutierrez? Aye. Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Aye. Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Peters? Mr. Peters votes aye.
Are there any members who have not voted who wish to vote? Clerk will report.
Mr. Chairman, 13 members voted aye, 17 members voted no.
And the amendment is not agreed to. Are there any other amendments to the amendment? Does the gentleman from California seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Just as someone on this side of the aisle who generally and genuinely tries to work on regulatory reform, I just wanted a minute to say why I'm not in favor of this particular item, and in fact was with the majority yesterday on the slush fund one. I came here after the sequester was adopted. It was an across-the-board meat-axe approach to cutting government spending without regard to the priorities involved with those cuts. We've seen that that has not been a good approach. It's been a real difficulty for national security. Generals and admirals have had to look at the line items on their budget to even move money off of landscaping to places where it's really needed. It's been tough on scientific research as we approach every year these impending cuts in the sequester. And not incidentally, it has not addressed long-term debt, which continues to increase and which was the stated purpose of that approach. The problem with this approach to regulation is it would graft that entire methodology and dysfunction onto the administration, which is the one branch that is continuing to deal with the issues issue by issue. And that is our job here. We ought to be taking up issue by issue the things that are in the way of a functioning economy and the things that need to be improved. This does not do that. This is a sequester for the administration. The judicial branch provides remedies for people who are aggrieved by regulations if they can show irreparable harm, likelihood of success on the merits. I feel that those are sufficient, and we ought to let the administration and the judicial branch do their jobs, and the Congress should do its job. This doesn't do it, and I'm opposed. I ask my colleagues to oppose it as well.
Chair thanks the gentleman. For purpose of the gentleman from Michigan, Mr. Trott, seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
I've been reticent to chime in on this discussion, although it's been interesting, but I feel necessary because we really have lost sight of what this bill is all about. And I had a meeting last week with some small business owners from my district. Can you imagine starting a small business today? What this bill is all about is not Zika. Zika might be affected if they decide to write a rule outlawing perfume and cologne. That might bring this bill into play. But can you imagine starting a small business today? The people I met with told me it's really death by acronyms. EPA, FDA, ACA, DOL, CFPB. It's nearly impossible to start a small business and succeed today. This rule tries to address that, and Washington continues to get in the way. The thousands of rules that we're writing are undermining the ability of the private sector to prosper and flourish. That's why we have an economic recovery that's at 1.1%. I yield back.
Question occurs on the amendment in the nature of a substitute to H.R. 3438. Those in favor will say aye. Aye. Those opposed, no.
No.
Senior Chair, the ayes have it, and the amendment is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 3438 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no.
No. No.
Ayes have it. The bill as amended is ordered reported favorably.
Record vote.
Ordered vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes aye. Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Ms. Walters? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes aye.
Mind is gone.
Mr. Trot? Mr. Trot votes aye.
Shell is there.
Mr. Bishop? Mr. Bishop votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson?
No.
Mr. Johnson votes no. Mr. Pierluisi?
No.
Mr. Pierluisi votes no. Ms. Chu? No. Ms. Chu votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes no. Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Peters?
Yeah. Oh, there they are.
Mr. Peters votes no.
Gentleman from Texas.
Not recorded. Ms. Jackson Lee votes no.
Has every member voted who wishes to vote? Gentleman from Illinois.
Mr. Gutierrez votes no.
Clerk will report. You had good participation today. Yeah. Yeah. I need that main hearing.
Where's your precious copy?
Mr. Chairman, 18 members voted aye, 13 members voted no.
The ayes have it, and the bill as amended is reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. I want to thank all the members for their enthusiastic participation in the markup of this bill, and the markup is adjourned.